Gaurav.
Hello, sir.
Huh?
How are you, sir?
Fine, fine. How are you?
Good, sir. Been better, but yeah.
Huh?
I've been better. I actually had dengue last week, so little.
No, happy that it was dengue, not corona.
Well, fortunately or unfortunately, I'm sort of immunized in that way also now.
Shall we start, sir?
Yeah, yes.
So let me introduce you today, our speaker. So, good morning to all the participants. Today we have Mr. Gaurav as our speaker for this FDP Phase 1 session, sponsored by AICTE, organized by the Department of Biotechnology, Oxford College of Engineering. So our guest today is Mr. Gaurav Mishra. He is a biotechnology engineer and lawyer with over 6 years of experience in the field of intellectual property. He is currently an IP manager and attorney at Banana IP Counsels, Bangalore. Mr. Gaurav's academic qualification includes he is a Bachelor's of Engineer in Biotechnology from our esteemed institution, the Oxford College of Engineering. So we proudly say he is the alumnus of our college. And he also holds a LLB from Karnataka State Law University, postgraduate diploma in intellectual property law from National Law School of India University. And he also holds an MBA in marketing management from Nasi Monji Institute of Management Studies. Gaurav is primarily involved in drafting and filing patent and design application with patent office across the world and developing strategic engagements with intellectual property firms around the globe. He is also responsible for prosecuting patent applications before the patent office, handling patent oppositions and revocation, managing the IP portfolios of his clients, offering patents and design strategy advice, dispute resolution, litigation management, and providing legal counsel to clients. Over the years, Gaurav has worked with several large companies, educational institutions, individual inventors, as well as startups on patent-related matters ranging from filing, prosecution to litigation management and dispute resolution. He is a key member in Banana IP Patents and Strategic Engagement Division and engages with several organizations across the world on strategic patent matters. He is also the key speaker at various events organized by the different government and non-government organizations, including educational institutions and companies. He is also the editor and author contributor of the IP blog Intellipedia, one of the world's leading IP resources. He is also the managing editor of the IP Press, which is also another leading IP blog with global readership. So we are very glad to have you here today, Gaurav. So it is from behalf of the student staff management of the Oxford College of Engineering, we take it a privilege to welcome you as the speaker here today. So it's a welcome, Gaurav. So please do start the session. So it is over to you.
Thank you. So actually, before I begin the session, I think I just take 2 quick minutes, because if I don't do this, I'd be failing in my duties. The fact that I'm here is, I mean, I would definitely like to give all my due thanks and credits to my teachers who are currently on the session right now, because I think a lot of what happened after college or during college was shaped up by all of my teachers here. For that matter, Salma ma'am, Valamati ma'am, Manjunath sir, Divakar sir, and the entire staff at the Department of Biotechnology, TOC. So I would definitely like to thank you all. So before I begin. All right. So now, in order to begin, there is one thing that I would like to request all the participants here. I want to keep this as interactive as possible, because I do not want it to be another webinar where you have a speaker speaking at one end and you are not interacting with the speaker. Primarily, obviously, this does not benefit us, because I want to be able to know that what I'm delivering is clearer, and received equally clearly. So I hope that is fine with everyone. What I would definitely request is when I put out a question, you can unmute. I believe there is an option to unmute the speaker by themselves, right? So you should be able to unmute yourself and join in the questions, join in the discussion. And so, yeah, let's just go ahead with it. Shares. So, are you able to see the PPT that I've just shared?
Yeah, we can see Gaurav.
Oh,
you can go
all
ahead.
right. Thank you. So before we begin with this, I think one question that I would like to ask is, I'm sure you've already discussed on what patents are. So let's begin with the very basic question and a premise that nobody understands what a patent truly is. So what do you think a patent is?
Participants can unmute and ask, or at least post your question answers in the chat box.
As I said, it is quite important for us to be on the same page. So what do you understand by a patent? Why do you file for patents? Okay, now I know, now I feel what a teacher feels when a student doesn't answer the question. Do we have any takers on what they mean or what they understand by patent?
We have an answer in the chat box, Gaurav, to claim ownership right.
Claim ownership right. Okay. So what right does a patent give you? What is this ownership right?
Gaurav, to have our exclusive right for our innovation.
Exclusive right to what?
For our innovation.
Right, but what is this exclusive right that you're talking about?
I don't want anybody to take the advantage of it, and whatever the commercial benefit that I get from my innovation, I want to enjoy it.
All right. So are you saying that if there is somebody who wants to use your patent non-commercially, as in they are not making any profit?
But if they want to use my innovation, they should pay some kind of royalty to me. Whether you make profit out of it or not, that is your business. But when I invent something, I expect something to be given to that innovation.
Right. So that is the kind of question that we intend to answer when we talk about patent infringement. So for the very first instance, the rights guaranteed by a patent are follows. Now, in case of a product patent, you have the exclusive right to stop a third party from making, using, selling, offering for sale, or importing any product which has been patented.
You can go ahead, Gaurav. Let's start.
There is some sort of an echo. So if you could just. All right. Now, in case of a process patent, you get a right to stop third parties from using the process itself and also stopping somebody from using, selling, offering for sale, or importing any of the products which are obtained by using this process. So the scope of a process patent is slightly enlarged because you're stopping somebody from not only using the process, but you also indirectly have a claim over the products which are manufactured by such processes. Now, these rights of a patentee are negative rights. It basically means it doesn't give you a right to manufacture, sell, but it gives you the right to stop somebody else from doing this. Now, when we talk about patent rights, there are obviously some sort of limitations. The first being patent rights are territorial in nature. So, pardon me. So patent rights are territorial in nature. With what I essentially mean by territory is, if you've filed a patent in India, if you've been granted a patent in India, your rights are limited only in India. You can claim infringement only in India and not in another jurisdiction, could be US, UK, Germany, etc. The other limitation is patent claim. Now, when I say patent claim, what do you think I'm claiming for? I'm sure the answer to that would be the invention, the innovation. Now, it's very important to know that what is not claimed is considered as disclaimed. For example, if I claim, let's say, a fan, which has, let's say, a wooden fan, right, which has around 4 wings or 5 wings, and then tomorrow I have a competitor in the market who comes up and he says, I'm offering the same product, but with a lot of modifications, which are not covered in this claim. In such a situation, he would escape infringement. And that is why patent claims are drafted in such a way that we give the broadest meaning and broadest interpretation as possible. Coming to infringement. We've already obviously discussed on what we mean by infringement, or unauthorized use, as we called it during the start of the session. Now, of types of infringement, there are 2 types. We have direct infringement and indirect infringement. When I say direct infringement, there are 2 further subcategories. One is referred to as literal infringement, and the other one is infringement by equivalence. In order to determine whether there is direct infringement or not, what we generally do is we refer to something as claim construction. As we move forward in this presentation, I will obviously share examples with you, and we're going to have an exercise, a discussion on how we construct claims. And obviously, when we've constructed these claims, our next job is to compare 2 products, 2 inventions, or an invention and a product. A direct infringement essentially is looked at claim by claim. For example, if I have a first claim, are all the elements of this claim present in the product that I'm putting across to you? So that would be the first claim. Then I move to the next claim, which is the second claim. More often than not, they are all dependent claims. So the first one is independent claim, which is broad enough, and it looks at covering the features of an infringing product, let's say. The second claim would be dependent claim. Third claim would be dependent on the first claim. Fourth claim would be dependent on the first claim, so on and so forth. So when we look at a claim and when we look at a product, you need to look at what is there in this claim and what is there in the product and see if these are matching up with each other. If there is matchup of all of these features, of all of these elements, then you say there is direct infringement. To begin with, claim construction. So a claim essentially has 3 parts. The first part is the preamble. The second part is the transition. And the third part is the body. As you might see, there is an example which is being provided below. A kit for detecting neurogranin comprising an isolated antibody for an antigen binding fragment so and so, and element B, component to detect binding, so and so. So this claim goes on. Now in the first part, you will notice that the preamble essentially tells what you're claiming. What is the subject matter, or what is the subject of your claim? As you can see here, it is a kit for detecting neurogranin. The transition phrase is usually one of these, depending on how narrow or how broad a claim is. There is comprising. Then we also use comprising of, consisting essentially of. So, and also in many cases, people use including, which narrows down the claim significantly. So the use of these transition phrases are very important, because comprising is taken to be the most broadest interpretation, whereas consisting essentially of is considered as the narrowest interpretation of a claim. Now, we have a question here. Ankita claims a ceiling fan comprising of a base connected to a solid rod, which in turn is connected to a rotor with at least 3 wings. What I'm looking at right now is for anyone in the participants to tell me or identify what the claim elements are in this claim.
Ceiling fan.
Okay.
Then connected to a solid rod, which is in turn connected to a rotator, and minimum of 3 wings.
Minimum of 3 wings. So the claim elements are a base. First element. The second element is the solid rod. The third element is the rotor. And the fourth element is wings. There is a competing product, which is as follows. A ceiling fan having a base to be attached to the ceiling, which has a hollow rod connected to the base, and the hollow rod is connected to a circular rotor having 4 wings. Now, if you compare this product with the first claim or with the patented product, do you think that Rahul's fan is infringing? Does Rahul's fan have a solid rod or a hollow rod? Hollow, okay. And what is the kind of rotor that Rahul's fan has? It's a circular rotor.
4 wings.
And 4 wings. Whereas the patented product has 3 wings.
3 wings.
Now, when we talk about direct infringement, it is important to know that all elements must be present in the claim or in the product which is considered as infringing. Now, do you think all the elements of the patented product are present in the infringing product?
No.
No. Why do you say that?
There is variation in the elements that are being claimed here for patented.
Okay. All right. So this product, I would say, is not infringing literally, because all the literal elements of the patented claim are not present in this infringing device. As you've obviously noticed, a ceiling fan comprising a base connected to a solid rod is not the same as a hollow rod. So in one, we have a solid rod. On the other hand, we have a hollow rod. Secondly, we have a circular rotor. And here there is a rotor which is mentioned, but does not clarify as to what kind of a rotor. The fourth one the third one is there are wings. Whereas Rahul's fan has 4 wings, the patented product has 3 wings or more.
Three.
Right. So in this last part of the claim, if you notice, it says a ceiling fan comprising of a base connected to a solid rod, in turn connected to a rotor with at least 3 wings. Now, if a fan that has 4 wings necessarily has at least 3 wings,
Yes.
so that product is actually covered by the patented claim. Now, the next question though is in terms of infringement, no, there is no literal infringement. But what function does the rod do? Is the hollow rod and the solid rod holding the fan in the same way? Do they have the same function? And finally, do they end up producing the same result? If yes, then this product is considered to be infringing by what we refer to as equivalence. Now, in terms of literal infringement, let's take another example. All elements of a claim are literally present. You have 2 products here, a pharmaceutical composition comprising 1 to 1.5 grams of compound X, 2 to 5 grams of diluent Y, 1 to 3 grams of excipient Z. The other one is a product, which is a medicated composition consisting of 1 gram of compound X, 4 grams of diluent Y, 1 gram of excipient Z. Now, if you compare these claims, can you tell me whether all elements are present? Is compound X present in the patented claim? And the product?
Gaurav, keep your chat box open because participants are posting the answers there.
Okay, just a minute. All right, so I think I've received all responses. Yes. So would you say the medicated composition infringes on the pharmaceutical composition that has been claimed? Right. Essentially because when we are talking about the infringement, all elements which are provided in the medicated composition, that is 1 to 1.5 grams of compound X, the product contains an amount of compound X which is covered by the first claim. Similarly, between 2 and 5 of diluent Y, there is 4 grams, and between 1 and 3 grams of excipient Z, the medicated composition contains 1 gram of excipient. Therefore, all claims, or in fact, all elements are present in this. And therefore, the medicated composition is said to be literally infringing the pharmaceutical composition claimed in the first part of the claim. Now, when I spoke about equivalence, we look at whether a certain element in a claim performs substantially the same function in substantially the same way to produce substantially the same result. So in our first example, when we took, Ankita's fan had a base, a solid rod, a rotor, and at least 3 wings. Rahul's fan has a base, so a base is present. Yes, they are literally infringing. A solid rod is present in Ankita's fan, but a hollow rod is present in Rahul's fan. So they are not literally infringing. The third one is a rotor, and Rahul's fan has a circular rotor. A rotor technically is broad enough to cover a circular rotor. So you could say it is present. There is literal infringement. And of course, Ankita's fan has 3 wings, but Rahul's fan has 4 wings. Now, Ankita's fan says at least 3 wings, which includes 4 wings. Therefore, Rahul's fan is believed to be infringing. But since there is no match between a solid rod and a hollow rod, they are not literally infringing. The courts actually developed, this was as early as in 1987, when the courts developed what is referred to as the doctrine of equivalence. Now, doctrine of equivalence is actually quite important in terms of finding out infringement, because it's very easy for somebody to say that, and this happens a lot in pharmaceutical compositions for that matter, because you have a number of viable substitutes or alternatives that are available for substituting, let's say, an active pharmaceutical ingredient or a stabilizer, filler, excipient, and so on and so forth. There is where we come down to the question of bioequivalence versus doctrine of equivalence. Now, when we spoke about doctrine of equivalence, we said there must be a element which performs substantially the same. Now, the keyword here being substantially the same. It is not the same. It is substantially the same thing. Or if I could put it in simpler words, similar to or similarly. This is, by the way, known as the 3-way test to determine infringement: function, way, result test, FWR test. If an element performs substantially the same function in substantially the same way and gives substantially the same result, then a product is said to be infringed by equivalence. Now, obviously, I think before I step into asking for what do you understand by bioequivalence, I would like to understand what is your idea about a generic drug versus a drug that has been researched, or a brand drug. Firstly, what do you think is the difference between the two of them? Do you have any answers?
See, generic drug is a drug produced using the patented product, which has got expired or which has got released, and a regular drug is a drug produced by a company. Am I right?
That's correct. But does a generic drug necessarily have to wait until patent expiry?
Need not to be.
Sorry, sir?
Need not to be.
Need not.
In case if it seems to be very essential for the society, the patent can be taken off.
Right. So, of course, that is something that has not happened in India for, I think there were only 2 cases, 2 compulsory license cases which were issued where the patent was not revoked, but compulsory license were issued. So, revocation of a patent merely because there is a need for a generic drug does not happen, but there is, of course, something known as issue of a compulsory license which happens. Now, what do we understand by bioequivalence? As obviously biotechnology, I think you are more qualified to answer this.
API which has got similar structure and function.
Mm-hmm.
API which has got similar structure and function.
Structure and function. Would that be it, sir?
So many other definitions are there.
Mm-hmm.
Composition wise, or it may be mimicking it structurally, and there may be a slight difference in its orientation, or maybe addition of some side chains. So many things are there.
Correct. So when we look at bioequivalence, there is a direct conflict with the doctrine of equivalence. Because what a doctrine of equivalence says is, if there is an element which has the same function, the same way, performs the same way, gives the same result, then there is infringement. But when we come to pharmaceutical compositions, we are looking at bioequivalence in drugs. And as obviously Manjunath sir has identified what bioequivalence is, we are looking at three essential things here: pharmaceutical equivalence, pharmaceutical alternatives, and pharmaceutical substitutions. When I say pharmaceutical equivalence, they are the same active ingredients, salts or esters, polymorphs, isomers. The dosage form is the same, the route of administration is the same, and they are identical in strength or concentration. So by the definition of a doctrine of equivalence, a bioequivalent drug is technically infringing. But the only reprieve here is in situations where bioequivalence is important, the doctrine of equivalence takes a step back. So in order for, at least for pharmaceutical compositions, the doctrine of equivalence cannot be used in exactly the same way as it is used in all other cases. Pharmaceutical alternatives obviously have the same therapeutic moiety with different salts, esters, complexes, polymorphs, isomers. This is something that we'll obviously discuss in the coming slides. And we have pharmaceutical substitutions, which is basically means of dispensation. So you have suspensions, you can give them as tablets, you can give them as topical ointments, and so on. Now, bioequivalence, of course, could not be considered as infringing a certain patent. But do you think bioequivalent drugs can be granted a patent or are granted a patent? If I may just quickly ask, so I understand you've been having this faculty development program for about 2 weeks. So have you touched upon Section 3 of the Patents Act or patentability requirements of the? All right. So when I say Section 3 requirements, do you think a generic drug can receive a patent with some changes to the composition, some changes to the pharmaceutical ingredients, some changes to the forms, in order to achieve this bioequivalency? No? Okay. All right. So bioequivalence has one enemy, at least under the Indian patent law, which is the Section 3D. Now, 3D essentially looks at stopping any company from evergreening its patent. By evergreening, I essentially mean claiming the same composition in different ways. So this was actually developed somewhere in 2008 or 9 when we came about the case of Novartis and Bayer, obviously. So what Novartis did was it basically tried to claim it already had a patent over imatinib mesylate, and it tried to file a patent for another form of the drug, the beta crystalline form of imatinib mesylate. The patent office obviously rejected it, and Section 3D was the biggest hurdle and has always been since then to most pharmaceutical manufacturers. So as a section, you can clearly see here, it is recited as follows: mere discovery of a new form of a known substance which does not result in a known enhancement of the known efficacy. Now this word efficacy also has been elaborated to mean therapeutic efficacy of that substance, or the mere discovery of any new property or new use of a known substance, so on and so forth. For the purposes of this clause, salts, esters, ethers, polymorphs, metabolites, pure forms, particle size, and all of these are to be considered the same substance, unless they differ significantly in properties with regard to their efficacy. Now, efficacy being therapeutic efficacy. Another section, obviously, which the patent office seems to recite in the examination reports that they send us for pharmaceutical compositions is Section 3E, which talks about obtaining substances which are a mere mixture or admixture, resulting in only the aggregation of properties. So what happens here is you need to show synergistic effect of these molecules or of these elements which are being claimed in your invention. So at least one thing is clear: between bioequivalence versus doctrine of equivalence, bioequivalence thrives. The doctrine of equivalence holds the second position. And when it comes to patentability, however, you cannot have a patent on a bioequivalent drug because of the presence of these sections, which is Section 3D and Section 3E. Now we have an example here. I'd like you to take 2 minutes to read this example, and then we will go ahead to compare. I would actually like you to note down the elements that are present here, and if possible, also share them in the chat box so we can then discuss on the slide after this. So you can take a minute. So are we clear with this? Can we proceed further?
Gaurav, you can proceed.
Okay. Now there is a company called Fruits and Fruits. This company sells fruit with flavors induced into them. It sells fruits like with grapes, and so on with orange, mango, and any other flavor induced into them. So there is a grape which tastes like, let's say, a watermelon, or a grape which tastes like orange. Now the company's process is as follows. The frozen fruits are sorted, sliced, and defrosted. Water or acid treatment is given to the fruits to remove their natural flavor. The fruits are immersed in sugar syrup and flavored liquids for about 3 hours, and air is blown on the fruits with force to dry them. Now compare this with the previous claim and tell me if there is infringement of or infringement by fruits and fruits. Yes, okay. So I'd really appreciate it if somebody could probably turn on their mic and help us understand. Obviously, all of you are right when you say yes, there is infringement. But for the benefit of, in fact, me and everybody else on the panel, it would be really helpful if you could probably help us understand why do you think there is infringement, based on what comparison?
Hello, you can hear me?
Salma ma'am? Rashmi?
You can hear me?
Flavor is induced. Okay.
You can hear me?
Is somebody talking? I am not able to hear very clearly. For the first part, can we just go back to this claim and read this claim out loud once? A process for preparing a flavored dry fruit product, said process comprising treating the dried fruit with an acidulant being selected from the group consisting of tartaric acid, malic acid, citric acid, ascorbic, phosphoric, and fumaric acid in an amount and for a period of time which is sufficient to substantially remove the natural flavor of the dried fruit. The next step is dehydrating the treated dried fruit to obtain a desired moisture content. And the third one is treating the dried fruit during step A or step B with a flavoring agent having a flavor which does not substantially correspond to the natural flavor of the dried fruit. As the treatment, correct. Flavor variation approach are same in both, correct. That's right. So now what I understand is obviously you connect to the fact that there is infringement of this product, and the court also held the same in terms of what has been claimed and what was being done in the process here. Moving on, when we speak about indirect infringement, we have two kinds of infringement. There is contributory infringement and inducement to infringe. When I say contributory infringement, it is basically the intentional participation or resistance to infringe. For example, when I have, let's say, I'm manufacturing a product which has steel rods, which has a frame, which has certain rings. There is another friend of mine or another company that says, listen, this is patented. I know that, but what we'll do is you continue manufacturing these ladders, okay? And I will provide you with the aluminium that is required or with the fitments that are required to assemble this ladder. Or if you would like to speak strictly in pharmaceutical terms, then let's say there is a company that is manufacturing a certain composition. And now this composition happens to be a patented composition. The first liable infringer is obviously the one who is manufacturing this composition, but he's not alone in it. There is somebody else who is infringing the patent, which is, let's say, for example, you have a company A, which is manufacturing this composition. Company B is the one that is providing company A with the diluents that are required. A company C is providing company A with the binders for their composition. Now, if you take all of these manufacturers or all of these vendors separately, they are all equally liable for infringement because they are contributing to the infringement. So it is not just company A which is liable, but also company B, C, D, and E, and whosoever in that line is involved in supplying materials which causes infringement. The second point is inducement to infringe. This is quite simple. You are encouraging, aiding, assisting someone to infringe somebody else's patent. This is more like friends saying, "Hey, it's okay, it's okay, do it," or let's bunk class. It's okay, we'll take care. Both of us are in it together. So, inducement to infringe is something like that. You basically induce the other person to commit a crime or to commit infringement, and in such an instance, you are also equally liable for infringement. Now, when we talk about infringement, there are obviously certain exceptions. You call them exceptions, exemptions, or defenses to patent infringement. The first one is government use. So any use by the government is considered as an exception to infringement. So any act which is done by the government, which in other instances would be considered as infringement, is not considered infringement here. Any use for the government. So, for example, if the government says, in fact, this is the current situation right now. So when the government says, okay, I want the Serum Institute to manufacture these vaccines, although you do not have a patent over it, then although you are a private company, let's say, you are manufacturing these vaccines or drug formulations. In such an instance, if you're manufacturing it for the use of the government or for the government, then there is no infringement. So by the government or for the government, it would count for as a defense to infringement. The second one is obviously research exemptions or Bolar exemptions. Now, Bolar exemptions are something that we will cover in the coming slides. Research exemptions, you have categorizations which are done in this. These include experiments, education, and regulatory approvals. Now, in order to receive a regulatory approval, you need to obviously have some kind of a test which needs to be done before you put out the drug into the market, or for that matter, before you go ahead and apply for approval. So this period of experimentation or the need to experiment before filing for approval in terms of research and development are all grounds of defenses against infringement. And then there is when you intend to use a certain patented product merely for the purposes of education. That is again a exception to infringement. I hope I'm clear on research exemptions or Bolar exemptions. because this is quite simple, but also can get quite complicated when it comes to regulatory approval and experimental studies, because what happened actually in the whole concept of the Bolar exemption in India was derived from the US case of Roche versus Bolar, where Roche actually said, listen, you are not supposed to be experimenting my patented drug for the production of your generic version. The court obviously ruled in favor of Bolar, and that is why we have the exception, which is now referred to as Bolar exception or Bolar exemption. So any study that is undertaken using a patented drug for experiments, for experimental purposes, for educational purposes, and for regulatory approvals would be exempted from infringement. The third one is parallel imports. Now, we spoke about the rights of patentees in the very first slide. And I said the rights are limited by territory, which is jurisdiction. So, for example, let's say I have a patent here in India. I do not have a patent in USA, or let's say I have a patent in USA also. And I have authorized someone in the USA to manufacture these pharmaceutical compositions or diagnostic kits or whatsoever. And somebody in the US purchases it from such a person and then sends it to India. Then he is not committing infringement. Although he is importing it parallelly. As a patent holder, you have the right to stop importation. But when we talk about rights and territory of a patent, India follows what is referred to as international exhaustion. For example, once you've sold off your patent or once you've given away that right, then you cannot claim infringement on that. So if you have a patent, you sold that product out to one of your friends, and that friend then sells it back here in India, you cannot stop somebody from doing that. So these are referred to as parallel imports. Then, of course, there are other defenses which are equitable defenses, if I could call them. They are patent misuse, inequitable conduct, latches, and all grounds provided under Section 64 of the Patents Act. Patent misuse is one of the most often cited defenses, where you say that a company is not using or is in fact abusing its patent rights. Whenever there is a conflict between a big pharma industry and a generic manufacturer, it is primarily the ground of misuse or abuse which is cited by the generic company. Inequitable conduct is obviously any conduct which does not become befitting for a company. Latches are delays. For example, if you have any kind of a delay in making a claim, you've gotten a patent in 2010 and you haven't been using it. Then I started manufacturing this pharmaceutical composition in 2012 or 2013, somewhere around that time. You knew it, but you didn't take any action. And later on in life, when my company became big enough, it was earning good revenues or earning good turnovers. That's when you realized, oh, I think it's now time to exploit. And then you come back and then you file a patent infringement claim. So the court would not consider this as a good thing, obviously. There has been unreasonable delay in filing of this infringement suit, because if you were really serious about protecting your invention, then you would have gone to the court earlier. So these latches are also a good defense that are used by most companies. And then we have all the grounds which are provided under Section 64. So Section 64 of the Patents Act actually deals with what is known as revocation of a patent, where you revoke the rights of a patent holder. And there are some 13 grounds on which you can revoke somebody's patent. Some of these include that your patent was invalid, it was sufficiently describing your invention, so it was granted incorrectly, it was obtained wrongfully, there was some material information which you hid. So there are several of these grounds which generally form part of a revocation proceeding. And all of these are actually or can be taken up as grounds for revocation as well as defense to patent infringement. Now, as we were speaking earlier, Bolar exemptions. Bolar exemption in India was first discussed in the case of Roche Products versus Bolar Pharmaceutical Co. This was a US case in 1984. Now, Bolar exemption in India has actually held a very prominent and important position because we are referred to as the pharmacy of the world. And merely in terms of the numbers, if you were to look, India's pharmaceutical industry supplies about 50% of the globe's vaccine demands. And in fact, it's quite nostalgic for me to say this because I was right there in Manjunath sir's class when he was explaining these things to us, and we were talking about pharmaceuticals in India and what is the kind of growth that we foresee, or what is the kind of contribution that India does in terms of its vaccines, in terms of its pharmaceutical manufacturers. So 40% of the United States' demand for generic drugs comes from India, as in we basically cater to 40% of their market, and then 25% of all medicine in the United Kingdom, which is a significant amount. And this 40% in the United States is despite the fact that almost all of the big major pharmaceutical companies come out of the US. So around 50% of their market is handled or held by the big pharma. 10% is actually alternative medicines, or how do I say? These are essentially patented drugs which have expired, which have lapsed, which have been abandoned, and so on and so forth. So these are nowhere. These are neither generic, these are not currently in force, nor are these being manufactured by the major industries. Now, Bolar exemptions in India, the reason, the necessity, the importance are obviously, as you can see, quite clearly listed here. We are talking about the drugs being exported to more than 200 countries across the world. And this is the data from last year, where India's generic companies received about 304 abbreviated new drug application approvals in the US. Now, Bolar exemption is very, very, very important in India because as a pharmacy unit where we are producing these drugs for the world, there is obviously going to be a spate of cases which intend to prevent generic companies from catering to these needs. So that has in fact always been the state of contention, at least in India. And the US has always been insisting on making our IP regulations in such a way that generic manufacturers necessarily have to pay huge royalties to a patent holder in order to even come up with these generic versions. Now, of course, we have been resisting it, and if we were to go ahead with it, then this would impact our pharmaceutical industry as well as the global demands for the kind of supplies that we provide them. Now, this is actually guaranteed, the Bolar exemption, although the word is not used in the Indian patent law, we do refer to this as the section 107A, and I've actually reproduced that here. So certain acts not to be considered as infringement. For the purposes of this act, any act of making, constructing, using, selling, or importing a patented invention solely for uses reasonably related to the development and submission of information required under any law for the time being in force in India or in a country other than India that regulates the manufacture, construction, use, sale, import of any product shall not be considered as infringement of patent rights. Now, the entire thing about Bolar exemption was, as we were talking, Roche actually had the patented drug, flurazepam hydrochloride. So it was selling this in the name of Dalmane. And what then happened was the United States Court of Appeals, as we refer to it, of the Federal Circuit. I think I also gave the reference to that here. So the Second Federal Circuit for Appeals. It basically said if somebody was to stop the manufacturing or a testing of a generic version, it would defeat the purpose of patents, because the objective of patent is actually to incentivize the progress of science and technology. So you need to have some safeguards, some exceptions, because entire or absolute monopoly is not in the benefit of anyone across the world. So there is probably no other country in the world which has benefited more from Bolar exemption than India. So as far as infringement are concerned, if I could do a quick recap, we are looking at two kinds of infringement. There is direct infringement and indirect infringement. Now, in direct infringement, we are again looking at two subdivisions. There is literal infringement or infringement by equivalence. Very important to remember that although the doctrine of equivalence applies across sectors, it is not specific to one certain field of technology or sector, that it applies specifically to mechanicals or to electronics or to electricals. It also applies to chemicals as well to the mechanical industry and as well to the biopharmaceutical industry. Pardon me. And when we speak about doctrine of equivalence, we are looking at the function way result test, which again, at least for biopharmaceutical companies or pharmaceutical compositions, is not the same thing that would apply for, let's say, a mechanical invention for that matter. When we look at the doctrine of equivalence, we are looking at whether an element is performing the same function in the same way and giving out the same results. Bioequivalence, in terms of its patentability, is obviously brought down by section 3D and section 3E. So it's actually quite difficult for us to obtain a patent on a bioequivalent drug. And in terms of whether or not there is infringement of a bioequivalent in respect of a patented molecule or a patented drug, it actually entirely differs on a case-to-case basis. So I cannot generalize and say that if you have a bioequivalent drug, you are absolutely free from infringement. That is not true. There are certain situations, there are certain cases where you might have a bioequivalent and you will still be liable for infringement for several reasons. And then in terms of indirect infringement, we had contributory infringement or inducement to infringe. Finally, we have defenses to infringement. or exceptions to infringement. Researchers, scholars working in universities, teachers, professors generally have always been exempted, not just under the patent law, but also under all forms of IP. For that matter, if I were to take industrial designs, for copyrights, so educational research, educational purposes have always been left out of the purview of the intellectual property right. So although you will have a right against somebody, but if these include something that is for the benefit of the public, for the public good, and again, especially within the, when I say public good, obviously it differs. What is public good for you might not be public good for me, and what is public good for me might not be public good for somebody else. So we eliminate all those discriminations and distinctions and keep it clear that these apply to experimental data, any experiments which are carried out during or after the phase of clinical studies, clinical trials, and then obviously the entire process of regulatory approval, from the time of filing for regulatory approval to the time of receiving the regulatory approval, are all exemptions to infringement. Then finally, of course, there's parallel imports and defenses that we spoke about. So this would be it from my end. Thank you. If we have any questions, you can post them to me on the chat box, or we could open the forum for discussion as well.
Thank you, Gaurav, for that. Participants, if you have any questions, please post it in the chat box or unmute yourself and ask.
Gaurav, can you highlight about the possibility of filing a patent using bioequivalence?
So it is possible to obtain a patent for a bioequivalent drug, but at least in India, this is one of the most difficult steps, because as I said, Section 3D talks about ineligibility of a patent as insofar as it concerns the structures of the form, of the manner of the way in which this drug is provided or administered. So all salts, polymorphs, ethers, esters, all of these are actually considered to be the same substance. So bioequivalent drug is, in all honesty, quite difficult to obtain a patent for. And in India, definitely. What generally happens is you will not claim the pharmaceutical composition. You can claim the use of this pharmaceutical composition, and you need to then frame it in such a way, or so to be honest, everything, I mean, see, it depends on how cleverly and how strategically we draft a patent application and what we intend to cover. So the whole purpose of a bioequivalent is to, you are using this as an alternative to a brand drug, right? You're trying to give them the same, you're trying to give the same results. So if there is a possibility where you are able to increase the therapeutic efficacy, even in consideration of bioequivalence, then you would be able to get, so your drug would still be considered in some ways bioequivalent, but in fact better. Because I believe
the patent is of synthetic compound.
Yeah.
And if I found an alternative from the natural source, how to go about it?
So are you talking about a synthetic compound?
Synthetic compound is already patented in a composition.
Right.
Okay, during my innovation, I find the same compound from a natural source, which was not explained in the patent claims.
Right.
So how to go about this?
So obviously synthetic compound is going to keep you completely out of the purview, because when you're talking about a synthetic compound, you're synthesizing it separately, and it is not being derived from the natural component. Now the problem with natural derivatives or natural components is, again, these are existing in nature, and that is why it's far more easier for us to get a patent on a synthetic or a synthesized compound rather than a compound occurring naturally.
I will define the utility of it. Natural compound may be existing, right?
Right.
I will explain I will explain its utility.
Okay.
And I'll get a claim for my utility, right?
So a patent is essentially issued for three things that we generally take into it. There is novelty, industrial applicability, and non-obviousness.
Yeah.
So you will never receive a patent merely for the utility of that patent. You need to satisfy the other.
See, suppose a plant is having a compound. I develop a process to isolate it. So for that, I will get the process patent, right?
Correct.
And then I will explain the utility of it. And using that, I will make one formulation.
Correct.
So formulation and the steps followed to isolate that compound and its utility.
Absolutely. So when we talk about utility, we essentially put the claim in a language such as use of a compound in the treatment of pre-diabetes or type 2 diabetes. So use of a medicated composition, or use of a compound of formulation comprising so and so. So there is generally, when we talk about patent claims, there are several different kinds of claims. We refer to them as Marcus type claims. Then we have product claims, process claims, product by process claims, use claims. So generally, if you see, at least in pharmaceutical compositions, there are three kinds of claims which are generally present. One is the process claim. The other would be the product claim. And the third would be the use claim. So at least 80 to 90% of all pharmaceutical patents have these three claims which are generally made: the process, the product, as well as the use.
And what if, right, naturally occurring compound is patented, right, and I am going to synthesize it and I will put a claim on it. Will it be approved?
No. So firstly, a naturally occurring compound will never be given a patent, because if
Right, one minute.
mistaken.
See, naturally occurring compound, as I explained, the claim will be for the process of extracting it or isolating it, and then process of formulating it, and then utility of it. Okay.
Correct.
Now, what I will do, same compound with the same structure, I will synthesize it. Okay. And then I will formulate it, and then I will show the efficacy of it.
Correct.
Can I file a patent?
Yes. So in such a case, it would not be considered as a natural compound, right? It would be considered as a synthesis. Exactly. So, for example, if I say I am taking out, if I just take out curcumin, and I say this is my compound, it is something that exists naturally. I mean, you obviously know the whole turmeric episode and the neem episode, right? We were essentially looking at companies which had attempted to claim these compounds. If you go back to those patent applications and look at the claims that they have made, they have claimed the formulation of naturally occurring substances. So that is not something, and that is something that was actually granted and then later revoked.
Yeah.
So and even under the Indian Patent Act, sections 3, as I said, we have from 3A to 3P. We have different, this entire section actually lists down what is not to be patented. So section 3, basically, section 3C talks about anything that exists naturally. Mere discovery of anything that is present or occurs naturally is not patented. And then we come to section 3D. Section 3D is essentially you're looking at evergreening. You're trying to stop evergreening. And I explained to you in terms of the how these polymorphs or how these crystalline forms of pattern of formulations are attempted for evergreening, and that's the whole purpose of introducing section 3D. So as you said, sir, obviously for a bioequivalent drug, you can definitely get a patent, but then you would not, at least in your own words, you will not want to put the hammer on your foot and call it an equivalent drug. Because the moment you say it's a bioequivalent, then it kind of defeats the purpose. So you will, obviously, when you go to the patent office, you will claim it as a new drug or a new formulation with enhanced therapeutic efficacy.
So you mean to say curcumin, if I can synthesize
Yes.
in the laboratory,
Yes.
right? And if I formulate it, and if I claim that my synthetic curcumin has got more efficacy, then I will get a patent on curcumin?
Absolutely. Not on the curcumin,
Not
but
on the curcumin, on my product, which has the same structure.
On the product which shows this sort of a therapeutic efficacy. So these words are very important.
Curcumin having the same structure, same property, but
The same
synthesized in the lab.
structure, the same structure, the same properties, but what matters is efficacy.
Okay, efficacy also, we will imagine that it is as having higher end, and but only the difference is it's synthesized in the laboratory.
Yes, so in such a case, it will not matter. So you will, at the end of the day, have to show a therapeutic efficacy. Once you establish therapeutic efficacy, you will be able to get the patent on the same molecule or the same composition.
If it lie in the same efficacy level?
Sorry, sir?
If the synthetic curcumin has the same efficacy level as that of a natural, still I will be allowed to file the patent?
See, you will file a patent. Okay, there is nothing in that. But as I said, there are certain things which could stop you from eventually getting a patent, which is novelty and non-obviousness, right? So novelty is still somehow easy to.
Both are there, no? Non-obvious because it is not existing. Synthetic curcumin was not existing. Novelty, I have invented the steps to synthesize the curcumin.
So non-obviousness is not just literally not being obvious. We talk about what is referred to as inventor step, right? So if there is something in the prior art is anything that exists before the day you file your patent application. So if there is information that exists in the prior art, then that becomes an impediment to your future patent filing. Now I know curcumin exists, right? I know what the efficacy of curcumin, naturally occurring or synthesized curcumin is. Let's say there is a company which has synthesized curcumin with in fact, a relatively poor efficacy, right? But I have come up with a curcumin with improved efficacy. The problem here is I know that curcumin exists. I know that the previous company which tried to achieve this had poor efficacy. So it becomes prior art, and it becomes obvious for a person skilled in the art to change certain compositions or formulations to achieve a higher efficacy. That is why it's important actually when we talk about these patent applications going to the patent office, very often pharmaceutical compositions face section 3D as an impediment, and we have to establish therapeutic efficacy as well as defend the fact that there is inventive step. So inventive step could be basically introduction of a new reactant, which increases the therapeutic efficacy. It could be introduction of, let's say, a new process, which again increases the efficacy. So all of these things, if you have, sir, then you will be able to get a patent. But as I said, it's not very easy to overcome section 2I, which is basically the inventive step requirement.
Thank you, Gaurav, for that informative talk. So they are the questions that were there. So nothing from the participants' end. So we will be officially concluding this session. So at the outside, on behalf of staff, students, and management of the Oxford College of Engineering, I thank Mr. Gaurav Mishra for being part of this FDP program and accepting our invite to be a speaker and enlightening the participants with what and what cannot be patented. So thank you so much, Gaurav, for being part of this FDP program.
Thank you, ma'am.